Welcome to the Probate Nation. My name is Richard Ruddy, and I am the host of the show this evening. People are living longer thanks to good health care and healthy lifestyles. But as we age, not everyone remains as sharp as they were earlier in their life. And frequently a loved one, a son or a daughter, is called upon to take on the responsibility of helping an elderly parent or family member with financial and medical decisions. Execution of highly recommended legal documents in advance can allow you to provide that help. But not everyone executes those documents in advance. And when the time comes for you to help that loved one, it may be too late to put those legal documents in place. If that turns out to be the case, you may need to take formal legal steps to get appointed to serve as the conservator and guardian of that loved one, and in the process begin the living probate train ride. Our show tonight will look at the process in Loudoun County to be appointed the conservator and guardian of an elderly adult who has financial resources, beginning with a petition to the court, the GAL investigation, the court hearing and probate office qualification, the ongoing oversight by the Commissioner of Accounts and others, and some common problems and pitfalls that often arise along this living probate train ride. With us tonight are two elder law attorneys to guide us through this process in Loudoun County. Rachel Downs is in a private law practice with the Leesburg law firm of Sevilla, Saunders, Huddleston, and White. Rachel focuses her practice on wills, trust, estate and trust administration, and guardianships and conservatorships. She's a member of the Loudoun County and Fairfax Bar Associations and the Trust and Estate section of the Virginia State Bar. Christine Moujon-Boll is a senior partner at the Laurel Brigade Law Group in Leesburg as well. Her practice focuses on all aspects of divorce and family law, as well as adult conservatorship and guardianship. Christine has been a faculty member for the mandatory Virginia State Bar professional class, served as the statewide president of the Virginia Women's Attorneys Association, and is currently the president of the Loudoun County Bar Association. Please welcome Rachel Downs and Christine Moujon-Boll. Ladies, welcome.
Thank you.
Thank you for joining us today. You know, Rachel, we talk about those types of legal documents that people can sign in advance that will make it less likely to have to go pursue a conservatorship. What are those types of documents folks need to consider doing?
Well, in the context of medical-related decisions, we're talking about an advanced medical directive, a living will, a HIPAA privacy waiver, possibly some kind of health care proxy that maybe the hospital or physician is going to want you to sign.
Okay. And from a financial standpoint, to take care of those bank accounts and brokerage accounts, what kind of documents could they do in advance?
Durable general power of attorney. And in some cases, someone might be creating a trust and they can appoint a trustee. It's also important that they contact their financial institutions and sign additional forms that may be necessary to make the power of attorney on record with the bank.
That's a very important recommendation. Even after you sign all those documents, though, is that going to preclude the need for a conservatorship or guardianship?
Well, the goal would be to at least minimize the risk of having to go that far.
Okay. So, Chris, we turn to you now. It turns out that folks have become incapacitated and they have not executed the necessary documents. How do they make decisions at that point?
Well, the problem is if they don't have those documents, many times they can't. A healthcare provider may work to some extent with family members on medical issues, but the more serious the situation, the more likely you're going to have some court appointment designation or one of these advanced medical directives. Same thing with the financial issues as well.
So the purpose behind, let's just break this down, the purpose behind a guardianship proceeding would be to get what kind of authority?
That's to take care of all the personal estate, the personal issues relating to someone. So anything dealing with their medical issues, residential issues, health, therapeutic treatment, anything to deal with the actual person as opposed to money.
Okay. And then so on the other side, to deal with the money side, what is the conservatorship?
That's the conservatorship petition, and you get appointed as a conservator, and a conservator manages all financial issues, so bank accounts, tax issues, Social Security, managing real estate, investments, anything to do with money and finances.
Okay, so these two proceedings are often referred to as the legal proceedings of last resort because folks have not taken care of doing the necessary documents. So let's talk a little bit, let's turn to how the process we actually go through in Loudoun County to to obtain a guardianship or a conservatorship. So the first thing that we have to really address is the bonding issue, and the bonding really is, people think about what does it mean to be bonded. So I know there's two different levels of bonding. One is for bonding you as a guardian, and that generally is not something that we have to worry about from a financial standpoint. It's just it's not backed up by any sort of surety. But the other bond is the one that we actually do get concerned about, which is the bond for the conservatorship, because that has to be backed up and approved by someone who's going to ensure someone's performance. So talk about the guardian bond first for us. You know, what is the type of bond that a guardian has to have?
Well, usually the court will set the amount of bond, and that can range to a minimum of $1,000 unsecured up to or higher, depending on what the court sets. And that is just so the idea is that you'll faithfully perform your duties as the guardian.
Okay, and so that's a personal bond. Now, on the conservator side, talk about the type of bond you have to get as a conservator.
Well, the conservator bond is one that actually has to be backed by the surety, or like having an insurance, okay? And in that case, the person will apply with the bond company and disclose how much assets they think they're going to manage. And then at that point, they'll see if you can actually qualify to get one.
So the reason we talk about bonds at the very outset of the discussion is that we don't want to go through this process of asking a court to appoint somebody only to find out they can't get the necessary bond as a conservator. So we want to get that checked out at the very beginning. Well, Chris, we've gotten past the bond, and now we have to figure out how we actually put this in front of a judge to communicate what it is we're trying to accomplish, and that's referred to as a petition. So tell us a little bit about the process. What goes into that petition to let the court know what we're trying to ask them to do?
The petition is a very specific pleading, and it's the requirements are set out in the statute, in the law. And you have to put general information. So regarding the petitioner, you identify who that person is, if they have a relationship with the respondent, and what powers they're going to be requesting as a guardian or a conservator. Then regarding the respondent, the incapacitated person, you have to indicate where they've been living, the level of their incapacity, if they're able to participate in any of the hearings. Information like what's their native language, has someone been caring for them. Generally, each petition is tailored with specific medical information regarding that person and that person's needs, residential issues, and then financially you have to provide information about their assets, their income, and their debts. If there are already some legal agents working for them under a durable power of attorney, those are identified. And you also have to include a specific list of family members with their names and their addresses, because those individuals will all receive a copy of the petition and a notice of the hearing, so people in the family know what's going on. And finally, every petition has to ask for the appointment of a guardian ad litem.
Okay. Now, with these petitions, is there a need to provide any sort of medical evaluation of some kind?
Yes, there's a medical evaluation report which has to be prepared by a licensed healthcare provider who has examined the respondent and has indicated that there is a medical need at some level for this incapacitated person. That report is filed with the court. It has to be filed before the hearing. It's technically filed under seal, so not everyone can read it. And other sensitive information like Social Security numbers are also filed under seal, so the public can't read that.
Okay. So you mentioned, Chris mentioned there is this need for a guardian ad litem. So this is very confusing to folks because they're filing a petition to be appointed guardian, and now they're appointing a guardian ad litem. What is a GAL? Who are these? Who is this person?
Okay, a GAL is going to be appointed through the court, so it's an independent process, but there are also people that have gone through a certification training process to make sure that they're going to be equipped to handle these types of cases.
Okay.
So those are the folks that would be appointed.
And what's the purpose behind, what's the role of the GAL in this process of getting someone appointed to be a guardian or conservator?
They're like an independent investigator. So they're going to go out and meet the petitioner, they're going to meet the person, the respondent, talk to standby guardians, review the medical records or the financials, and make sure that what the person's asking for is appropriate in this case.
Okay. And then they eventually file a report with the court? Is there certain things that the guardian has to tell the respondent when they visit them? And give them certain rights that they have to advise them
Yes,
about?
they're going to have to give them a certain statutory notice that discloses to the respondent exactly what's happening, and their right to a jury trial, and the fact that they're going to lose certain rights through this proceeding, the right to counsel. So there's going to be a mandatory notice that they have to give, let alone probably meet with the respondent and ask them, do you want this person to serve as your guardian, if that's even possible under the circumstances?
Okay. So Chris, we've gone through that process. We filed a petition, GAL's filed a report. We need to get a court order entered, so we need to go to court.
That's correct.
How long does it take to get to court?
In Loudoun County, if it's not contested, so there's not a dispute as to whether or not there needs to be a guardian or conservator or who should be one, you can probably get into court between 5 to 8 weeks from the time of filing.
Okay, okay. And when we go to court, we have a date that's been everybody's notified about that. Who has to show up?
The proposed guardian and conservator, which can be one person or two different people, the guardian ad litem needs to be there, counsel of record, and sometimes the respondent. It depends on whether or not they can participate in the proceedings.
Okay. Now, sometime in these petitions, they will ask for a standby guardian to be appointed as well. Does that person need to be there as well?
No, they're a backup and they're identified in the pleadings, but they don't need to be present at that time.
Okay, good. We're in court. How long does it take for the hearing to actually take place?
If it's uncontested, about 15 minutes, so the
Okay.
court can review the proposed order, set the bond, as we discussed earlier, and enter the final order.
So we've been talking about uncontested. What happens if it all of a sudden becomes contested?
If it's contested, then really it's a trial with an evidentiary hearing, and it can last a couple of hours or a couple of days. Depends on how much evidence needs to be presented, who wants to put their name in, and what the issues are.
Okay, okay. Well, Rachel, we've gone to court. You know, we need to get a court order actually entered. You know, is there just a form document we use to give to the court, or require some thought?
Yeah, no, it's not a form. Usually the order is going to be very specific to the case. So it's going to identify the parties, the powers of the guardian, the bond issues, who's going to serve as conservator, and any other matter that's relevant in the case.
So the judge signs the order and he hands it to you. At that point, does the person who's been appointed have the power to do anything?
Well, at that very moment, yes, they have the power, and third parties should recognize it, but there's the other step of actually going and qualifying at the probate office to actually get your letters of administration, and that's what the third parties are looking for.
Sure. So that leads us down to the next thing, Chris. Okay, we walk out of the court with the file and we have the court order in our hand. We need to go down to the probate office and have them do the final step and get everybody sworn in. You know, how quickly can we get that done?
What you should have done is made an appointment about half an hour when you're expected to be out of court to go down to the probate office, because it is by appointment. So if you have an attorney, they're going to set that up for you.
Okay.
So you can walk out of the courtroom and then go downstairs and meet with the probate clerk
Okay.
and have all of that documentation processed.
So at that point, there's a need for a bond for a conservator. Is the bonding company going to be there to sign off on things?
Many times we can coordinate with the agent to be there at the time, but Loudoun County being a small county, many times as long as the bonding agent can come sometime that day, assuming that your conservator has been pre-qualified, like we talked about, and then that won't be an issue.
What's the amount of bond that we have to have? How is that calculated?
The court, the judge, when they sign the final order, that's why they look at the value of the financial estate, and
Okay.
they always apply a bond that's at least the amount of the estate plus expected income plus a little bit more. There's not a real multiple in Loudoun County,
Okay.
but just to give an extra cushion.
Okay, that sounds good. Now, what type of document am I going to get when I'm at the probate office once I've done all that paperwork that will show that I'm actually in charge?
When you walk out, you have letters of qualification.
Letters of qualification.
One for the guardian and one for the conservator, and you can get numerous copies for a small extra fee, so you can give originals to different institutions.
Okay. Now, does the probate office provide any written materials to kind of explain to folks what they've got to do all of a sudden?
They do. You walk out with a very lengthy packet of information, which is very good. It's very clearly written and explanatory, because there are a lot of duties and obligations. So you get a fairly lengthy packet to go home and review several times. It's also on the website. Loudoun County has a very good website with questions and answers.
They do. This is posted online, but it's the instructions and duties of a conservator that's been prepared by Mindy Hetzel, the Commissioner of Accounts, and the probate office out in Loudoun, and they've done a fantastic job. And this document will be posted on the Probate Nation website as well. Okay, so this all gets done, but it doesn't get done for free. I mean, there's a lot of lawyers involved. Who pays for all this stuff?
Well, that's going to largely depend on the assets of the respondent. And the court's going to take a look at the circumstances and see what their level of income is and decide, okay, well, who's going to pay for the fees then? Because by statute, if the respondent has money, they have to take that into consideration, in which event then maybe the petitioner can get reimbursed for all or part of their fee.
Okay, so we have petitioners' fees for their counsel. The GAL fee is a lawyer, they get paid depending on the circuit. There may be a doctor's fee to be paid for a report of some kind as well. Okay, so once we've been qualified, we have this beautiful package of information, and part of it begins to tell us about a bunch of reporting obligations that we have. So what about the reporting obligations we have as a guardian? What are those?
Those you have to report to the Department of Social Services. And there is a pre-printed form, which you can expand on a little bit, and you have to file it initially 6 months after your initial qualification as guardian, and thereafter every year. And that just requires some information to make sure that the guardian has visited the respondent, they know what the living situation is, they know what the medical requirements are, and that you're just not doing this from afar, that you actually have a relationship with the guardian, with your respondent.
Okay.
And you need to report to that. And there's a $5 filing fee, so it's minimal.
It is minimal, but it is important.
It is important, and it needs to be filed yearly after the initial 6-month filing.
And we will, there is a specific report that we will also post on the website, and it's also available, I believe, on the Loudoun County website that shows you what you have to file with the Department of Social Services. Well, apart from them, we have our ever-popular Commissioner of Accounts, who keeps track of all the money for everybody, and we have to report to her as well.
That's correct.
Tell us about those reporting obligations.
The reporting requirements for the conservator are a little bit more detailed, and you do need to be a pretty good record keeper. So when you're first appointed as the guardian, within 4 months, you have to file the inventory, which is a list of the assets. That needs to be filed. 6 months after your date of qualification, you have to file your first accounting. And an accounting basically is a very detailed, in essence, a spreadsheet of all the money that you have received and all the money that you have spent. So the first one is filed 6 months after the date of qualification. And thereafter, you have to do it every year on that same 6-month anniversary. So
Okay.
it's 18 months and thereafter. And there is a fee that's going to be based on the value of the estate, and the Commissioner of Accounts will help you calculate that fee.
And those forms as well will be posted. Please be aware that the accounting form for the conservatorship is different than the accounting form for an estate. So you want to make sure you get the correct form when you're reporting. Well, there's a lot going on here. And undoubtedly, you guys have seen problems and pitfalls that folks run into and encounter. So, let's talk about that. What are some of the common problems and pitfalls folks need to be aware of that they should, be particularly concerned about as they start this process?
I think the due diligence on the front end is so important, and investigating whether or not the person actually needs a guardian or a conservator, or if there's a less restrictive alternative, and trying to work through those issues on the front end, because it is a public process and it is expensive, and it can be delay when, usually in a crisis, you have to be able to act immediately. So there just should be more work done on the front end to see if there's some other alternative that will work.
Okay.
And I think that goes with sitting down and talking with family members early on. We often think that a guardianship and conservatorship is going to be needed for someone who's elderly, but it can be as a result of an accident. It can be as a result of a medical condition that suddenly you might even need temporary assistance. So it's the kind of conversation that it's good to start early with your family. And also to identify who are the best people. As I said, a conservator has to have meticulous records. So you don't want to appoint someone who can't balance their checkbook, or for them that's a challenge. You really need to think about who would be best to do that kind of job. Then you have people who are much better at dealing with doctors, medical issues, making sure that the daily needs are met. So one of the big issues is to, whether you're talking about it early or you've already filed the petition, making sure you appoint the right person for the right job. That's why it can be one person or it can be two people, and there's nothing wrong with having a separate guardian and conservator.
Okay. Well, it sounds like it's important to have some frank discussions, especially within the family, so the folks don't become surprised when someone is doing something. Well, again, there's a lot of moving parts here, and obviously this program can only begin to scratch the surface about how to go about doing this. But given your experiences in our conversation today, you guys have any final comments or thoughts or guidance you want to share with the viewers as they may be considering, a Loudoun County conservatorship or a guardianship?
I think hopefully that there have been discussions so there's no surprises, that the person who's seeking to be obtained guardian, if there's multiple siblings or otherwise, that they've sort of worked together and everybody's on the same page so that we agree on who it's going to be in that situation. And hopefully at that point then working together to get the process moved forward as quickly as possible.
Okay. How about yourself, Chris? Any other suggestions you can share?
If you get to the point that you have to file for a guardianship or a conservatorship through the courts and one is appointed, a lot of people will see that as a negative. But actually with reference to the side of the conservatorship, because there are those very stringent accounting requirements, sometimes that helps the family to get a sense of relief, and they know that someone is taken on that job, and not only is there a formal person who's doing the accounting, but it's being reviewed by an independent overseer, the Commissioner of Accounts, and they do a meticulous job of reviewing those accountings to make sure that the money that's being managed by the conservator is being managed correctly, and all that information has been provided. And the Commissioner of Accounts can be a great help to commissioners, to conservators regarding, if they have questions. So even if you have to be part of that process, in the long run, it can be a positive versus a negative, particularly if you've had sort of a contested family situation. It can help calm some of the fears of the family and ensure that their loved one is being well taken care of.
I want to echo that particular sentiment. I know that we have previously had a conversation with Commissioner Hetzel, and she very much, takes her job very seriously. But she is a tremendous resource as she tries to make sure that folks don't get into a conflict and tries to resolve things, giving everybody a chance to have their say, sitting around our conference room table if it need be. But she wants to make sure everybody comes away happy and where everybody's still talking to each other. Because ultimately, we're really trying to take care of that particular respondent who has some particular problems that need to be addressed. So.
And that door is always open. I know even attorneys will call her because issues come up. And so even if someone is a conservator, if they're falling a little bit behind schedule, they should never hesitate to pick up the phone and call, whether it's Loudoun County or any other Commissioner of Accounts, to ask either for assistance or a little bit more time or some evidence that's not included in that initial document that you're given when you first qualify.
Absolutely true. Well, Rachel and Chris, I want to thank you so much for taking the time to sit down and talk with us today. It's just a lot of information, and it's a great public service to the citizens of Loudoun County, so thank you again for doing this.
It's been our pleasure to be here.
Thank you.
Thank you very much.
You're very welcome. Our population continues to get older every day, and with the passing of time, many of our elderly are no longer able to make good medical and financial decisions for themselves. There are several recommended legal documents that could be executed in advance to allow someone you select to make decisions for you when that time comes. But many of our seniors have not taken advantage of that planning opportunity, and as a result, a living probate called a conservatorship and a guardianship may be necessary. As the discussion with our guests illustrate, there is much that will need to be considered and done to file and successfully prosecute a petition for a conservatorship, beginning with working with the family, filing the petition with the court, preparing an appropriate court order and having that order entered by the court, getting qualified in the probate office, and much more. This can and often is a complicated process and certainly not a fill-in-the-blank kind of legal proceeding. We strongly recommend that you seek the advice and assistance of an attorney who has experience with adult conservatorships and guardianships should you need to take the living probate train ride. This brings us to the conclusion of our show today on adult conservatorship and guardianship in Loudoun County. Hope it was informative, and remember that replays of the show can be viewed on the Probate Nation website. On behalf of myself and the Probate Nation, thank you for visiting with us.